gears and focus on the foundational document itself. It's time to discuss the Constitution. Definition, role, and significance. So what is the Constitution at its most fundamental level?
Well, simply put, it's the fundamental law, the bedrock law, according to which a politically organized society, what we call the nation state, is governed. It's the core law that actually creates all the institutional pillars we talk about: the legislature, the executive, and the judiciary.
And why does a democracy actually need a constitution? I mean, beyond just setting up the government, what other crucial roles does it play?
Oh, it plays at least 7 key roles, all absolutely crucial, especially for managing a modern, diverse state like India. First, it provides the basic institutional arrangement, creating those 3 branches we just mentioned. Second, it lays down the norms governing the relationship between these institutions, what lawyers call the inter-se relationship. Think about how judicial review acts as a check on Parliament's power to remove a judge, for instance. That's the Constitution defining that relationship. And third, critically, it governs the state-citizen relationship, particularly through things like fundamental rights, making sure state power has clear limits.
Now, here's where it gets really fascinating for me. The sources point out it's not just a document of ideals, but also of conflicts. Can you unpack that conflict side a bit?
Yes, absolutely. It definitely captures the high ideals and aspirations. You see those shining through in the preamble and amplified in the Directive Principles Part 4. But, and this is important, it also serves as a kind of mirror, reflecting the real conflicts that existed in society when it was written. Think about the debate over the name itself in Article 1. India, that is Bharat. That specific wording, that's a compromise, reflecting a real argument about what to call the new nation. Or look at the provisions for scheduled castes, scheduled tribes, and minorities. Those didn't appear in a vacuum. They directly reflect the deep-seated historical caste and communal conflicts the framers had to grapple with.
And that's where that identity piece fits in, right?
Yeah.
The point made by Ramachandra Guha that the Constitution simultaneously reflects and creates an Indian identity.
Precisely. It also acts as the nation's national birth certificate, in a way. It's often the very first document a country frames when it emerges from colonial rule or monarchy, like Nepal did more recently. But perhaps its most profound role, especially for a country as incredibly diverse as India, linguistically, religiously, regionally, is providing a common normative home. What does that mean? It means a minimum set of shared rules. Rules for cooperation, for coexistence, and for coordination, essential for survival, let alone prosperity, as one single nation.
That historical analogy you mentioned really clicks then, like Ashoka's Dhamma. Historian Ramla Thapar argued it wasn't just a moral code, but actually a political tool to hold the vast Mauryan Empire together.
Exactly. And its final function, perhaps the most essential in many ways, is that it guarantees limited government. It places clear, legally enforceable limitations and restrictions on the government. Provisions like Article 13 do this. It ensures the state doesn't just run wild, that it doesn't become an absolutist regime. It keeps the government constitutional.
Okay, moving forward then. Let's clarify the relationship between the actual text of the Constitution and the evolving legal world around it. Let's discuss distinctions. Constitution, constitutional law, and conventions. Is the Constitution the only thing that really matters?
Oh, not at all. Not by a long shot. Constitutional law. That's a much, much wider term. It definitely includes the bare text of the Constitution, yes, but it also encompasses all the judicial interpretations over the decades, all the amendments that have been made, and crucially, these things called constitutional conventions.
Right, these constitutional conventions. So what exactly are these unwritten rules, and why should we even follow them if they aren't actually, written down in law?
Good question. They are basically customary ways of doing things. They are not backed by the force of law, legally speaking, but they are followed almost as if they were law. Why? Because they ensure the system functions smoothly, predictably. Think about the convention that the president invites the leader of the party with the majority in the Lok Sabha to form the government. That's not explicitly spelled out like that, but it's a fundamental convention. Or the expectation that a government must resign if it loses a vote of confidence, a majority vote. Again, a convention, but a vital one.
It really raises a powerful critical thinking point for you, the listener, doesn't it? Why does the stability of our whole democratic system sometimes hang on these unwritten, almost gentlemen's agreements, rather than just hard law? If these conventions are violated, you don't technically break a law, but you risk seriously destabilizing the whole setup.
Exactly. Conventions act like the essential grease in the wheels. They fill the gaps where the Constitution itself is silent, particularly in making the Westminster-style parliamentary system we adopted actually work in practice.
Okay, let's transition now to how the courts actually keep this document relevant and alive. Let's talk about interpreting the Constitution. Why is interpretation just so vital to how our government actually functions day to day?
Well, because the interpretation ultimately determines the scope of action for everyone, the legislature, the executive, even the judiciary itself. How we read the law dictates what the state can do and perhaps more importantly, what it cannot do.
The Supreme Court has developed a pretty sophisticated toolkit for this over the years. Before we get into those, what about tools found within the Constitution itself? Are there internal aids?
Yes, there are. We use internal aids like Article 366, for instance. It provides definitions for certain specific terms like Anglo-Indian or scheduled castes and scheduled tribes. Then there's Article 367. It basically authorizes the use of definitions from a much older law, the General Clauses Act of 1897, for interpreting legal jargon used within the Constitution. And crucially, Article 12 gives us the definition of the state. This is absolutely fundamental for applying Part 3, the fundamental rights.
Okay, so those are internal guides. Now let's explore some of those powerful tools that the Supreme Court itself has evolved over time. Starting with a fairly simple idea. Commonly held meaning.
Right. This is pretty straightforward. We interpret English words used in the Constitution based on their generally accepted common meaning. Unless, and this is key, the specific context clearly requires a different interpretation. Think about the word date. If it appears in a law about, say, food processing, the court isn't going to think it means a calendar day, right? It clearly means the fruit. Context is absolutely king.
And what about reading all parts together? This sounds pretty fundamental too.
Oh, it absolutely is. It's the core idea that the Constitution isn't just a collection of separate articles. It's a legal ecosystem. You can't just pull out Article 19 and interpret it in total isolation. You have to read it in light of Article 21, in light of the preamble, in light of all the related articles. The court very deliberately avoids treating articles like, watertight compartments.
The preamble. People often call it the soul of the Constitution. How does the court actually use it in interpretation?
It uses it through what's called preamble-based interpretation. If there's genuine ambiguity in a provision, if it could be read in more than one way, the court must choose the interpretation that best aligns with the philosophy and the grand vision laid out in the preamble. Things like justice, liberty, equality, fraternity. But there's a caution here. You cannot use the preamble to create an interpretive problem where the text itself is actually crystal clear. It's a guide for ambiguity, not a tool to invent it.
The court's ability to view the Constitution as an organic, living document that seems to have led to this idea of progressive interpretation.
Yes, and this is arguably the most transformative interpretive tool the court has used. The idea is that interpretation has to be flexible. It needs to adapt to accommodate shifts in socioeconomic conditions, political realities, societal values. The absolute best example, the explosive, unbelievable expansion of Article 21, the right to life. Originally, it might have just meant protection against being arbitrarily killed by the state, but through progressive interpretation, it now encompasses the right to a dignified life. That includes the right to health, a clean environment, privacy, a speedy trial. The list goes on and on. It's vast.
What if we need to understand what the people who wrote the Constitution actually intended? What tool is that?
That's purposive interpretation. Here, the court tries to figure out the underlying intent or purpose behind a specific provision. And how do they do that? Often by consulting the huge volumes of the Constituent Assembly debates. Those records give invaluable insight into what the framers were thinking, what problems they were trying to solve when they wrote that particular clause.
Okay, let's imagine a scenario. Say, two provisions seem to be in conflict. Maybe a fundamental right clashes with a directive principle. How does the court resolve that tension?
Right, that's where harmonious construction comes in. The principle is that if two provisions appear to conflict, they must be interpreted in a way that allows them to, reconcile and harmonize with each other. The goal is to make them work together, not to strike one down unnecessarily. And alongside this, there's another important principle. Interpretation should generally be done in favor of the citizens. We call this liberal interpretation, especially when fundamental liberties and security are at stake. The Supreme Court's landmark decision upholding the right to privacy a few years back. That's a prime example of the citizen-centric liberal interpretation in action, even when the government argued against it.
And finally, what happens when the text is just silent on a particular issue? Does the court sometimes borrow ideas?
It does. Where the Constitution itself doesn't provide guidance, the courts can, and sometimes do, refer to Westminster Conventions, those established practices from the British parliamentary system to help with interpretation.
All right, let's move to our final, really critical concept for today, constitutionalism. This is all about putting limits on the government, isn't it?
Absolutely. At its heart, constitutionalism, an idea largely derived from John Locke, the father of liberalism, is the fundamental principle that government power must be limited. It must operate within and adhere strictly to the body of laws that impose those limitations. Constitutionalism is essentially the direct opposite of absolutism or tyranny.
And the first major device or tool that ensures constitutionalism is the rule of law, an idea famously articulated by A.V. Dicey. What are its core pillars?
Dicey laid out three main pillars. First, the supremacy of law. This is that ancient idea, Rex the law is king, not the king, or the government, being the law. The government must run according to established legal principles, not whims. Second, the absence of arbitrary power. This means power shouldn't be granted in a way that allows officials to use it based on their personal preferences or biases. Decisions must be based on law, not arbitrariness. And third, equality before law. This means everyone, regardless of status, is equally subject to the ordinary law of the land administered through the ordinary courts. No one is above the law.
Now, the source material points to a significant challenge, or maybe an exception, to the rule of law right here in India, that immunity under Article 361 given to the president and governors. Why is this so controversial?
Yes, Article 361. It grants the president and state governors complete protection from any criminal proceedings, whether starting new ones or continuing pending ones for the entire time they are in office. The criticism, and it's a strong one, is that this feels like blindly copying that old Western, specifically British idea that the king can do no wrong. Critics argue that's fundamentally inappropriate for India because our president and governors aren't monarchs above the law. They are creations of the Constitution itself and should be subject to it.
And we have seen historical cases where this immunity seems to have been, allegedly misused.
We have. The source material specifically mentioned the 1995 case involving Sheila Call. She was appointed governor, and the allegation at the time was that this was done quite deliberately to halt ongoing criminal proceedings against her. So this tension between upholding the dignity of these high offices and ensuring basic accountability under the law is a really central ongoing debate in our constitutional practice.
And the tension is very much alive today, isn't it? What's the current controversy surrounding Article 361?
Right, the Supreme Court is actually grappling with two major related questions right now. First, is this immunity genuinely absolute? What happens when very serious allegations, perhaps corruption or even criminal conduct, arise against someone holding these offices? And second, a newer question. Does the same immunity automatically extend to centrally appointed lieutenant governors, LGs, like the LG of Delhi? This came up prominently in the context of VK Saxena. So this whole issue, the clash between executive immunity and democratic accountability, it's really a live wire, a true acid test for how robust our rule of law really is.
Okay, the second major device working towards constitutionalism is the separation of powers.
Yes, the core idea, famously put forward by Montesquieu, is actually quite simple. The power to make laws, legislative, the power to execute or implement laws, executive, and the power to judge laws, judicial, must be kept separate. Why? To prevent any one person or body from accumulating too much power, which inevitably leads to tyranny. Combining them means absolute power. Now, India doesn't follow a super rigid separation like the US model. We follow more of a system of checks and balances. Each branch can check the others.
But India also has several necessary, you could say, intentional departures from a really strict separation. What are some key examples of this overlap?
Yeah, we see a few major ones quite clearly. First, there's the fusion of the executive and the legislature. Ministers who form the core of the executive must be members of parliament, the legislature. They sit in both. Second, there's delegated legislation. Parliament often passes laws that are just skeletal frameworks. The detailed technical rules and regulations needed to actually implement the law, those are often filled in by the executive branch, by the bureaucracy. So the executive is essentially exercising a legislative function there.
And we also see the executive and even specialized bodies exercising judicial functions too, right?
Exactly. That falls under administrative adjudication. You see the rise of quasi-judicial bodies. Think of tribunals like the Central Administrative Tribunal, CAT, which hears specific types of cases outside the regular courts. Or even administrative officials like district collectors running revenue courts, exercising judicial power. Furthermore, sometimes you see judicial lawmaking, often called judicial activism. This is where courts step in, maybe interpreting existing law very broadly, or even filling a legal vacuum where Parliament hasn't acted. The classic example is the Vishaka Guidelines from 1997 on sexual harassment at the workplace. The court laid down the law because Parliament hadn't.
And what about all those regulatory bodies that have sprung up, especially over the last few decades?
Ah, yes, the regulators. Bodies like TRAI, the telecom regulator, are really significant departures from strict separation. Why? Because they often combine all three powers. They make rules, legislative, they implement and enforce them, executive, and they often adjudicate disputes arising under those rules, judicial, all within one body. But even with all these overlaps, the underlying principle of separation is formally reinforced in the Constitution itself. Think of articles like Article 50, which explicitly directs the state to separate the judiciary from the executive.
Wow, that was a truly comprehensive dive. We covered strategy, the Constitution's role, interpretation, and these big ideas of rule of law and separation of powers. Let's wrap up with that comprehensive recap, just like we talked about at the start, for active recall, like our coffee discussion wrap-up.
Sounds good. So we kicked off by identifying that success in this area really demands an application-centric approach. That means, interpreting the demand of the question precisely, looking beyond just the surface, and critically, daily writing practice. Can't stress that enough. Then we define the Constitution itself as the fundamental law, the bedrock that provides a common normative home for our incredibly diverse society. And crucially, it guarantees limited government.
Right. And we made that key distinction. Constitutional law isn't just the text. It's the text plus all the judicial interpretations, the amendments, and those vital unwritten constitutional conventions. And we saw how the courts use sophisticated tools like progressive interpretation to keep the Constitution a living, breathing document, making it relevant to today's challenges, especially, as you highlighted, in expanding fundamental rights like Article 21.
Exactly. And finally, we dug into the core devices of constitutionalism itself, the rule of law and the separation of powers. We looked at Dicey's principles for the rule of law, supremacy of law, no arbitrary power, equality before law. But we also acknowledge the real-world challenges, particularly that ongoing tension surrounding executive immunities under Article 361. That's a major point of friction. And with separation of powers, we saw India uses a system of checks and balances, allowing for necessary overlaps like delegated legislation and tribunals, while still upholding the basic principle.
Okay, so here is the final critical question we want to leave you, the listener, with today. If constitutionalism is fundamentally about limiting government power, and yet these intense debates over immunities for the highest officials, they continue to rage, even reaching the Supreme Court, what responsibility does an informed citizen like you have? What's our role in ensuring those constitutional checks and balances actually remain effective against potential executive overreach?
It really is the essential tension, isn't it, of any functioning democracy. As Justice Holmes famously said, the life of the law has not been logic, it has been experience. And remaining vigilant, constantly aware of that inherent tension between individual liberty and government authority, that's the ongoing, lifelong work required to maintain a truly constitutional state.
Thank you so much for joining us on this deep dive. We encourage you to continue exploring these absolutely fascinating and vital concepts on your own.